And also, Judge, if I may, for those of you who have waivers or whatever, I switch with Miss Champion. If you all would, just send it to my attention. Thank you. Or anything that the judge needs to sign as well.
And Ms. Falk, you did get that. Okay, thank you. Good afternoon, courtroom 2.
Hey, Judge Morrow, how you doing?
I'm doing well, Norris. I hope you are as well.
Doing wonderful, sir. A little bit of pain, but I'll be fine.
I'm sorry to hear that.
Sir, in front of you, we have position number 20, Ms. Turner, and then I'll also bring position, I believe should be position number 5, Ms. Franklin afterwards.
Okay, thank you.
All right.
Good afternoon, Ms. Turner. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Yes, thank you, ma'am. You have been charged in case 23 CR 004302J with reckless conduct. Good afternoon, Ms. Jackson. Is there a history?
Good afternoon, Your Honor. The defendant does not have any prior arrests on file. She appeared to meet the criteria for UJR through the jail. Nothing in addition.
Thank you. Ms. Falk?
Yes, Your Honor. This incident happened July 8th, 2023 at 2506 Lakewood Avenue Southwest. Defendant Franklin spoke to the officers first. She stated she arrived to conduct business with her ex-boyfriend, Mario Head. She stated that she and defendant Turner engaged in a verbal altercation while standing on the front porch about defendant Franklin wanting to be with Mr. Head. And then defendant Turner stated that defendant Franklin came to Head's home with a 9mm handgun. Defendant Turner stated that she went into the house, retrieved Mr. Head's handgun, returned to the porch, and the two of them engaged in a fight. During the fight, the gun accidentally discharged, at which point defendant Franklin went back to her vehicle and called police. Mr. Mario Head, who is the ex-boyfriend of defendant Franklin, current boyfriend of defendant Turner, stated that defendant Franklin and Turner had a heated phone conversation a few days prior to this incident. Defendant Franklin arrived at the house armed with a firearm and demanded that defendant Turner step outside. Defendant Turner then retrieved Mr. Head's firearm from inside the house, went out to confront defendant Franklin. A pushing match ensued, according to Mr. Head, and defendant Turner's gun accidentally went off. So what we have here is essentially two people with firearms getting into a physical altercation where one of their firearms accidentally discharged as a result. The state's recommendation as to both is a $7,500 surety bond, no further contact with one another. We are further asking that defendant Franklin have no further contact with Mario Head. We are also requesting defendant Franklin stay away from 2506 Lakewood Avenue and no alcohol, drugs, or weapons as to both. And we are also requesting one-day anger awareness as to both. So I gave Your Honor essentially the summary of both defendants and their recommendations, because
Franklin
one have history.
Is Franklin on the calendar today? Oh, yes, that's
Yes.
position. Position.
Correct.
Okay. Okay.
So she's going to be called up immediately after.
Okay. And Ms. Franklin is her first arrest as well?
That is correct, according to her GCIC, Your Honor. But we
Okay.
do have some serious concerns here. The fact that both of them brought guns is highly problematic. And the fact that the gun discharged, understandably, it was said accidentally, but the fact that there was a discharge of a weapon also gives the state serious concerns about the judgment of these two ladies.
And the Lakewood Avenue address, is that Ms. Turner's address?
This is my client's address, Your Honor.
That is correct.
Okay, all right. Yes, good afternoon, Ms. McLeod.
Good afternoon, Your Honor.
You can proceed.
Yeah, my client is 46 years old. As pretrial has noted, she has no criminal history whatsoever. My client has a PhD degree. She is employed. She's never been in any kind of trouble. This woman came to my client's house after making threats to her before, and she came with a gun on her hip. Naturally, my client is entitled to protect herself. So she, this woman showed up at her house. She had no business there at all. She simply has been chasing after my client's fiance for some time, and she is one of those people who does not take no for an answer. So she showed up at my client's house, and naturally my client was in fear because she had a gun at her hip when she came to the house. So my client did not fire the firearm when she was attacked by this woman. She had the firearm and the firearm went off. I would ask the court to give my client a signature bond so she can get out of jail and get back to her life. And we are definitely in agreement with the state about Ms. Franklin staying away from my client and from her home, and also from the gentleman involved that she claims she was coming to see. Ms. Franklin claims she was coming to see. Nothing further, Your Honor.
So is Mr. Head with either Ms. Turner or Ms. Franklin?
He lives
Your
with
Honor.
my client. They are engaged.
And my understanding was that that was her boyfriend. That was repeatedly stated in the report, never mentioned it was fiance. I will also state that this is Mr. Head's residence, and Ms. Turner stated she lives with Mr. Head. We are still asking for the stay away as to Ms. Franklin. Additionally, it was Mr. Head's statement to the police that this appeared to be a pushing match between the two of these individuals that resulted in the gun going off.
Well,
Okay.
we're not disputing the fact that this woman attacked my client at all, but remember, she came to her residence. Ms. Franklin does not live there. She had no business coming to somebody's home to attack them and to be carrying a gun. Quite frankly, I don't think the client should have been arrested because she has a right to stand her ground.
Okay. Given that this is Ms. Turner's first arrest, it's going to be a $5,000 signature bond through pretrial per the judge, 1-day anger awareness, no further contact with Ms. Franklin, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms.
State
Turner.
would renew its request for a 1-day anger awareness, and
Oh.
just wanted to emphasize that no firearms is part of that condition.
Okay, so
Well,
Ms.
the
Falk,
judge
I'm
did
sorry.
say the
Hold
anger
on.
awareness.
Okay, yeah, if I missed it, I want to make sure that I said anger awareness.
You did.
wanted-
You did.
And thank you. And if you, Ms. Turner, just to Ms. Falk's point, if you do have any firearms at the present time, you're going to have to relinquish them until this is dealt with. Okay, good luck to you, Ms. Turner.
Thank you, Irma.
You're welcome. And so I guess we'll go to Ms. Franklin, position 5 next.
Give me 1 second, y'all.
Okay. Mr. Freeman, Arthur Freeman, can you unmute for me?
Okay, can you hear me?
Yes, I appreciate you being here this afternoon, Mr. Freeman, but please conduct yourself as though you're actually in the courtroom with me. If you would like to, if you like to eat, if you please just turn your camera off, and you can eat as much as you want, but when you have your camera on, be respectful of the court, okay?
I'm sorry, sir.
If you're fine, you don't have enough for everybody, you know. What do they say? All right, Mr. Freeman.
Yes, sir. I'm sorry.
All right, you're fine. Thank you. I accept
Okay.
the apology.
All right. Mhm.
Ms. Franklin, good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video? Thank you. You've been charged in case 23 CR 004300J with reckless conduct. It's my understanding that this is your first arrest. Do you have anything to add to the recitation, Ms. Falk?
No, Your Honor, we're asking for, again, we're renewing our request for a surety bond on this case as well.
Okay, and that's a $7,500 surety bond.
Yes. Your Honor.
Yes, good afternoon, Ms. Wills.
Good afternoon, Your Honor. My client is 54 years old. She has resided in the state of Georgia and in the Atlanta area for the past 11 years. She is employed by Piedmont Healthcare. She works in their accounting division. She has a bachelor's degree from DePaul as well as a master's degree from Keller Graduate School of Management. As it was stated, this is also her first arrest. My client states that she went to Mr. Head's residence to address his girlfriend or Ms. Turner's behavior toward her, and that Ms. Turner had previously threatened my client. And so she went to his residence and they had agreed to speak about the issue so that they could rectify it so it would not continue to be a concern for my client. My client states that when she arrived to the residence, she was speaking with Mr. Head. Ms. Turner was behind him. And then Ms. Turner lunged at her, causing all three of them to fall down. And that is when Ms. Turner's gun went off. My client was legally and lawfully carrying a firearm. She has the right to do that. She never at any time brandished it, and that is not the accusation, and it wasn't her gun that went off. I think for all of those reasons, a signature bond would be appropriate for my client as well. And she has no desire to return to Mr. Head's residence or to have contact with Mr. Head or Ms. Turner at this point.
Given that it's Ms. first arrest also will also be a $5,000 signature bond through pretrial per the judge, 1-day anger awareness, no further contact with Ms. Amanda Turner or Mr. Mario Head. Stay away from the 2506 Lakewood Avenue address. No drugs, alcohol, or weapons while out on bond. Just to reiterate, Ms. Franklin, if you do have a firearm, you're going to have to relinquish it until this matter is resolved. Good luck to you, Ms. Franklin.
Thank you.
Your Honor, what's that bond amount? I apologize.
No, you're fine. $5,000 signature bond through pretrial.
Thank you.
You're welcome.
Next, we're gonna bring up Mr. Bobby Green.
Mr. Green is number 9 on the calendar.
Yes, Your Honor.
Good afternoon, Mr. Green. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Green, you've been charged in case 23 CR 004311J with possession of marijuana less than an ounce, possession and use of drug-related objects, and 2 counts of giving false information to law enforcement. Is there a history, Ms. Jackson?
Your Honor, the defendant does not have any prior arrests on file. The defendant appear to meet the criteria for UJR through the jail.
Thank you. Ms. Falk?
Yes, Your Honor. This incident happened during a traffic stop that was on, excuse me, Your Honor, my system is taking just a moment to update. That was on July 8th, 2023. This defendant was stopped with another individual in his vehicle who was arrested and who on outstanding aggravated assault warrants. This was at the location of 1981 Joseph E. Boone. They observed a black Chevy Impala. They saw the defendant. As soon as they walked into the location, they noticed a male lean over and reach toward the vehicle's floorboard and appear with what appeared to be a clear plastic bag containing a green leafy substance, which the defendant then placed in a pocket behind the vehicle's driver's seat. The officer also smelled a noticeable odor of raw marijuana coming from the vehicle. The defendant was asked to step out. A Glock 33 was recovered sitting in the passenger seat, as well as a black satchel bag. Inside the bag was a Glock 19 and a Taurus 38, as well as 20 grams of raw marijuana recovered from the pocket behind the driver's seat, where the officer observed the defendant moving over and placing that green plastic baggie into the pocket behind the seat. Additionally, when both parties were read their Miranda rights, Mr. Green took responsibility for the Glock 33 sitting in the seat, and he stated the bag and firearms belonged to his kinfolk. Mr. Sturgis, who was with him, stated that he knew the firearms were in the vehicle and that Bobby Green knew the deal. And that was the context of this case. Additionally, the defendant initially gave the false name of, and let me just locate this really quickly. Gave the false name of, sorry, my apologies, Your Honor. Gave the false name of Tavares Thompson to the officers and gave the false date of birth of June 30th, 2005. We are recommending on this case a $5,000 surety bond. We're going to recommend a $3,000 surety bond. It's split between giving false name, the 2 counts, so $1,500 per count, a $1,000 surety bond on the possession of marijuana less than an ounce, and a $1,000 surety bond on possession of drug-related objects. We're also asking for no alcohol, drugs, or weapons, that the defendant have no further contact with the person he was in the vehicle with, which is Mr. Sturgis. His first name is Mexike, which is Mexike. And we're also asking that he have absolutely no alcohol, drugs, or weapons. That's all for the state.
Okay, so Mr. Green, was he the driver of the vehicle?
He was in the driver's seat. Yes, Your Honor.
And what was he pulled over for?
It wasn't that he was pulled over. When the officers entered, they were actually at that location and saw the defendant's vehicle facing westbound at the gas pumps, with the defendant sitting in the, and I apologize, with the defendant sitting in the passenger seat, not the driver's seat.
Okay.
So they were in that area, the officers were in that area, saw what they appeared to see the defendant having drugs in his hand, then walked over to the vehicle, smelled the strong odor of marijuana, which then led to them asking the defendant to step out of the vehicle.
Okay. Yes, Ms. Wills.
I don't really understand that stop or how an officer can see unless my client was waving marijuana around in the passenger seat, which would make no sense. I also think it would be, it's irrelevant that he had or that there were guns located in the vehicle, as my client is not charged with that or any kind of distribution charge. My client is just 18. This is his first arrest. I've had the opportunity to speak with his mother, and I would ask for a signature bond, which is the recommendation of pretrial services. His mother was unable to attend court. However, and I'm not sure, I did share the link with her, but she did say that his grandmother, Miss Barbara Muhammad, was on her way down to the jail, and that she would be able to sign.
She's here in courtroom too. Sorry.
Thank you.
Okay, thank you.
So Miss Muhammad is willing to sign or be the co-signer on his signature bond if Your Honor is so inclined. My client did just graduate from Douglas High School, and he is a native of Atlanta.
Move on, man. Can I
Is
say?
he, hold on a moment. Is he working, Ms. Wills?
He is not currently working. He states that he recently left his past job and he is currently seeking employment.
Okay. Now, who wanted to address the court?
Yes, mom, Bobby Green mother.
And where are you, ma'am?
You can't see me, sir?
Oh, there you go. Okay. Good afternoon, ma'am. Can you raise your right hand for me?
Yes,
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes, Judge.
Okay, you can put your hand down. Thank you. What would you like to tell the court, Ms.
Yes, I am
Green?
the parent, the mother of Bobby Green. My name is Darlene Hannah.
Yes, ma'am. And you want to tell me something about your son?
Sorry, it was not a traffic stop. My son was sitting at the gas station, just pumped gas, and I put gas in my vehicle, and the officer took it upon themselves to go to the gas station because they're known for their area. And when they walked up, my son was just get through pumping gas and getting into my vehicle to pull off. He was waiting on Mr. Sturgis to come outside of the store.
Okay, and it's my understanding that Bobby hadn't been in any trouble before?
No, sir, my son he still play video games. He works, he just started working at Wendy's for about a year, 2 years and a half. He just started working at Wendy's and he was going to school. He don't go outside at all.
Okay, and he stays with you in your home?
Yes, sir. He live with me and my other 3 kids.
Okay, all right.
Oh, okay.
Anything further, Ms. Green?
No, my name is Miss Hannah. No, sir. I just wanted to let you know.
Okay. I'm sorry, Miss Hannah. Thank you. All right, so it's going to be a $500 signature bond per charge, which I need for you all to be quiet. The Samsung, you'll mute yourself. Can we get the Samsung muted, please? $500 signature bond per charge, which makes for a $2,000 signature bond through the jail. No drugs, alcohol, weapons while out on bond. Mr. Green, if you have, while you're out on bond, you're going to have a curfew from, you're going to have to be in unless you're working by 10 o'clock at night, and you can't leave until 6 o'clock in the morning. So if you're working, then you can work past 10 o'clock. But if you're not working, you're going to have to be home by 10 o'clock at night. And that'll be it. Good luck to you, Mr. Green.
Your Honor, we'd like to renew our request for a stay away from Mr. Sturgis, given the circumstances.
I don't really know who Mr. Sturgis is. Was Mr. Sturgis charged with anything?
He is currently being held as to aggravated assault charges. Yes, Your Honor.
It's my understanding.
But that was from just to be clear, that was from an outstanding warrant, but he is in custody on aggravated assault charges. And there were a number of guns in the vehicle with Mr. Sturgis.
And who is Ms. Wells? Do you know who Mr. Sturgis is? Yes, ma'am. Who is Mr. Sturgis? You can, Bobby's mom?
Yes, Mr. Sturgis, Judge. Mr. Sturgis is my boyfriend.
Oh, okay.
You want to speak to
I don't need to speak to the grandmother because he's got a signature bond. Has he had any problems with your boyfriend?
Judge, me and my boyfriend, we live together with Bobby Green. So the curfew, stay away from Mr. Sturgis is going to be very hard, sir.
Okay, I'm not gonna make him stay away from Mr. Sturgis at this point in time. All right, good luck to you all.
Thank you.
And Your Honor, I would just like to make it clear, Mr. Sturgis was also charged with possession on this case with possession of firearm by a convicted felon. So there should not be any weapons in the home since Mr. Sturgis is a convicted felon.
Okay, and you understand that, ma'am, and I don't know if you have any weapons or not, Mr. Green, but if you do, you cannot be around any firearms. You have to relinquish any firearms, and you've heard what the solicitors has said, ma'am, so beware. Okay, good luck to you, sir.
Thank you.
next we have position number 17, Ms. Cisco, and she has a private attorney.
Okay.
Come on.
Afternoon, Judge. How are you?
Yes, doing well. Good afternoon. And Ms. Sturgis, good afternoon to you as well. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Yes, thank you. You've been charged in case 23 CR 004317F with criminal trespass. Is there a history, Ms. Jackson?
The defendant has 3 cycles. The defendant's last arrest was April the 16th, 2023 in Fulton County for simple assault. That case appeared to be still pending. That case number is 23 CR 00373 and the letter F. The defendant does have 1 prior misdemeanor conviction. It's in 2021 out of Cobb County for a DUI. Nothing in addition, Your Honor.
Thank you. Good afternoon, Ms. Bickerstaff.
Good afternoon, Judge Morrow. How are you?
Doing well, thank you.
Okay, so this incident occurred yesterday at 3372 Peachtree Road at the Icon Buckhead Apartments. And this is where the defendant entered the lobby of the Icon Buckhead Apartments, and she was previously arrested there due to a fight and criminal trespass. So while in the lobby, I'm sorry, Your Honor, are you getting feedback from me?
I am. I can still hear you, but I am getting feedback.
Okay, I'm having issues with my sound on my computer, so I have it on my phone. Let's see.
You probably have to turn one
Is
of
this
them
better?
off, right? Yes, go ahead.
Okay. So while in the lobby, the defendant was causing a disturbance, and the defendant is not a resident at that location. So for these reasons, the state's recommendation is a $1,000 surety bond to stay away from 3372 Peachtree Road, the Icon Buckhead Apartments, as well as no alcohol, drugs, or weapons while out on bond.
Counsel?
Judge, that sounds perfectly amenable to us. Her mother and father live here in Paulding County. She's got a sister in Paulding as well. And so she's got family local that will help her, but that sounds very fair, Judge.
Okay, if no objection, it'll be $1,000 surety bond. Stay away from the Peachtree Road address, no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Cisco.
Thank you, sir. Judge, thank you so much. That's all I have. May be excused.
Yes, you all have a good afternoon.
You too.
Next, you're only going to have position number 2, Ms. Bynum, position number 2.
Good afternoon, Ms. Bynum. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, Ms. Bynum?
Yes.
Okay, you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 004297F with criminal trespass. Is there a history, Ms. Jackson?
The defendant has 16 cycles. The defendant's last arrest was June the 18th, 2023 with the City of Atlanta Police Department for criminal trespassing. Those cases, she received, it was actually 2 cases where she was charged with criminal trespassing. It was another one was on May the 24th, 2023. And she received a suspended sentence on them both. One was for June the 8th, that's the disposition date, June the 8th, 2023. The other one, she received a suspended sentence on July the 6th, 2023. She does have 1 prior felony conviction that was in 1990 for burglary. And she has misdemeanor convictions. This one in 2011 for driving without a valid license. And one in 1999 for criminal trespassing and simple battery. Nothing in addition, Your Honor.
Thank you. Ms. Falk?
Yes, Your Honor. This incident happened July 9th, 2023. So yesterday at 2273 Country Club Drive Southwest. Officers observed a Black female walking off of the property, and they identified that person as the defendant. The defendant stated her son called her and told her to drop off food. They questioned her son. Her son stated he never told her that and actually wanted to Mr. Rosella Walker, who's the caretaker of Miss Bailey.
Ms. Falk, I don't know if it's me, but you're going in and out.
And is defendant's aunt, Miss Eunice Bailey, is the defendant's aunt.
Ms. Falk.
Miss Walker, caretaker.
Yeah, she's freezing up real bad.
Yeah.
Hello?
Okay, hold on just a second. Let me see. If I can
Okay.
Okay.
hard connect.
Hello?
Ms. Bowers, I'm gonna need for you to mute yourself and stop walking around for me, okay?
Okay.
Is that better?
Yes, go
Okay.
ahead. Would you mind starting from the top, Ms. Falk? I'm
Sure.
sorry.
So July 9th, 2023, at 22773 Country Club Drive Southwest, officers observed the defendant walking off of the property. The defendant was identified as Miss Bynum. She stated her son called her and told her to drop off food. Her son was asked by the officers if that was correct. Her son said he never told her that and actually wanted to meet somewhere else. Miss Rosella Walker, who is the caretaker of Miss Eunice Bailey, who's the homeowner, stated that she called and that the defendant was trespassing and refusing to leave. Eunice Bailey is the defendant's aunt. When the officers then made contact with the defendant, she attempted to flee, was caught down the street and detained. Furthermore, Ms. Walker reported that the defendant tried to make entry by placing her hand through a hole on the side of the door to actually try to come into the residence, but wasn't able to. The primary concern the state has on this case is the two previous cases. Both cases were for coming onto that property after being asked repeatedly to stay off the property. At 2273 Country Club Drive Southwest. Both cases, Your Honor, actually adjudicated. The first was on June 8th before Your Honor, and the second was on July 6th before Your Honor. And as a condition of both of those cases, Your Honor imposed a stay away from that address. The most recent stay away was July 6th, which released the defendant from jail, and it was 3 days later, and she's back on the property in violation of both of those cases. And one case was subsequent to the other because, again, she had violated the conditions of bond. So despite being given bonds to stay away from this location, Senate's orders to stay away from this location, she's still coming back to the location. And I don't know how many ways they can tell her to stay away from the property. For that reason, the state is requesting a $5,000 surety bond, stay away from 2273 Country Club Drive Southwest. No further contact with Eunice Bailey or Miss Rosella Walker. And we both are here today to speak with the court.
Okay. Let me again remind everyone that this is a court proceeding, Ms. Blaylock. Okay, I understand that you might have someone that you want to see, but these are serious offenses. Everybody deserves their time before me, and you're distracting by doing what you're doing. So please, everyone, if you will please conduct yourselves as if you were actually in a courtroom with me. And if need be, turn your cameras off until your case gets around. But I truly hope I don't have to say that again. Let's see, Ms. Bailey, I see that you're with us this afternoon. If you would like to address the court, now is your opportunity to do so. You do not have to, but if you would like to address the court, you'll have to unmute yourself, activate your camera, and I'll have to swear you in. Okay. Doesn't appear that Ms. Bailey wants to address the court. Ms. Falk, as far as those did she take a plea the previous times?
Yes, Your Honor, she did. She entered a plea to a suspended sentence, which included serving a substantial amount of jail time. I believe she was in jail for over 30 days, the last sentence she received, and received a suspended sentence. And again, before Your Honor, with the conditions to stay away. Having watched Your Honor do these proceedings before, I have no doubt you advised her very clearly to stay away from that address.
Okay, thank you. Ms. Wells.
Thank you, Judge. My client is 59 years old. I have had the opportunity to speak with Mr. Odell James, who is my client's brother. It seems like there is some sort of dispute about this property. What Mr. Odell and Ms. Bynum shared with me is that this home was the property of an aunt who is now deceased, and that my client was living there up until a month ago, and that her aunt's former partner is now dating someone new who no longer wants my client in the home. And again, my client and her son, they were both living in the home up until the aunt passed away. And speaking with Mr. James, he states that my client's son is a student at Georgia State University. So he no longer resides at the home. He lives on campus and has lives in the dorms there. My client does state that she receives disability for her back. She will qualify to be represented by the Public Defender's Office. She has 2 years college. And in speaking with Mr. James, he did state that and indicate my client would have somewhere else to go if she is unable to return back to the property. I am not sure if my client has any belongings that are still there, but if so, I would ask for a one-time law enforcement escort so that she could pick up anything else. And I just want to say this for my client, that this might be a civil matter as opposed to, so that to prevent her from getting any future criminal trouble that she might have to go through the courts to address any concerns that she has in regards to the property. But I am requesting a signature bond. I do understand that my client has been there before. But that is my request of the court.
And Your Honor, I will add that the previous bond orders did include a one-time law enforcement escort for belongings. I can't imagine she still has belongings at this residence at this point.
Okay, Ms. Bynum, let me just say, you have a right to remain silent. Anything you say can be used against you. A lot of times people think that what they want to say is going to help them, which in actuality, it does not help them. It just ends up getting you in more trouble. So I'm sure that Ms. Wills, I'm happy to let you speak with Ms. Wills, but you do have a right to remain silent, and there are solicitors that are prosecuting you here that are listening to everything that's being taped today. So Ms. Wills, do you want to instruct your client?
Yes, Ms. Bynum, please, if you have any questions, just give me a call. Do not say anything. The judge is going to give his ruling, and anything you say can and will be used against you, and it can potentially affect your bond. So please don't say anything. If you have any questions, I'll be happy to speak with you after court.
And Ms. Bynum, apparently I've seen you not once before, but twice before. And apparently both those times I've asked you to stay away from this Country Club Drive address. And here we are back again. So I want to make sure that you understand that you can't go, no matter whether you think that you have a right to be there or not. You cannot go to 2273 Country Club Drive. So I don't know. And again, that's been in a previous order. You shouldn't have been there. And had you not been there, you wouldn't be back where you are now. So this time it's going to be a $2,000 surety bond. Stay away from the Country Club Drive address. Did you ask for a no contact with anyone, Ms. Falk?
Yes, Your Honor. And I was not aware that Eunice Bailey is deceased. We would like to ask still for a no further contact order with Miss Rosella Walker. And my understanding is Eunice Bailey is still alive. I understand what the PD's office said, but we talked to Miss Walker, and our understanding is Eunice Bailey is indeed still living.
Who is Ms. Walker?
Well,
that was per our conversation with Rosella Walker, who's the caretaker of Miss Bailey.
Okay. And I didn't get a name. I was just told the aunt passed away a month ago. So I wasn't told what the aunt's name was.
I will say the homeowner is her aunt, Miss Eunice Bailey, is the homeowner at that address. So I'm not sure where the confusion is, but Eunice Bailey is the homeowner. She's her aunt. She is still alive.
Okay, well then stay away from Miss Bailey. No drugs, alcohol, weapons while out on bond. Ms. Wells, do you think a social worker visit would be helpful for Miss Bynum?
I don't think it could hurt. So
okay, I mean, Ms. Bynum appears to be a bit agitated this afternoon. I would like for someone to go talk with her. If she doesn't have housing and she does get out, then let's help her with that. All right, Ms. Bynum, good luck to you, ma'am.
And Your Honor,
something else, Ms. Falk?
Yes, we would like to include Miss Rosella Walker, and I believe her full name is Rosella Walker Bowers, who is Miss Bailey's caretaker, and that no further contact.
Okay, this Miss Bowers that's on the line here?
She is, Your Honor.
Okay, and did you wanna, you have anything you want to tell me, Miss Bowers?
It appears
well,
she's
you-
trying to speak, but she needs to.
I was wondering why they were saying that Miss Bailey was deceased and she's right here. And Miss Bynum has not been living at this address. I know I've been here since December, not to count time coming back and forth, to take care of her and Ronald Brown. But I don't know nobody deceased here, and she got a son here, that's true. She got a son here, that's true. But every time she comes here, she just hellish. All kind of stuff she can do, all kind of mischief, all kind of ugliness. She just brings it with her. And nobody has time for that kind of disturbance of the peace of this address. There's no peace ever when she's around. That's just what she
Okay.
do.
Thank you, Miss Bowers. I appreciate it. So you've cleared some things up for the court. Thank you.
Okay.
All right. Who do we have next?
All right, I'm gonna go to the conflict cases. I'm going to go to position number 11 and position 18.
Okay.
Algrove is 11 and Thomas is 18.
Yes, good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Hartman. Is that a yes? Was that a yes? Yeah, thank you. You've been charged in case 23 CR 004304E with disrupting a public school. Is there a history, Ms. Jackson?
No, Your Honor, the defendant does not have any prior arrests on file. The defendant appeared to meet the criteria for UJR through the jail. Nothing in addition.
Hey, Ms. Bickerstaff?
Yes, Your Honor. This incident occurred on April 20th of this year at a Young Middle School at 3116 Benjamin E. Mays Road. And this is where the defendant went into Young Middle School to address a fight involving her daughter, ST. And as she was leaving the school, Miss Lakeisha Ray started calling Mrs. Thompson a bully B word and said that I'll beat your A. And so Mr. and Mrs. Thomas and the defendant re-entered the school and they began arguing and behaving disorderly to a point where the middle school staff had to intervene. And the defendant continued to argue with Miss Lakeisha Ray even while she was in handcuffs, and the defendant had to be restrained because she tried to approach Miss Ray several times. So for these reasons, the state's recommendation for Ms. Hargrove is a $3,000 signature bond through pretrial services, no further contact with Mr. and Mrs. Thomas or Ms. Lakeisha Ray, as well as no alcohol, drugs, or weapons while out on bond. And I'm sorry, I meant no further violent contact with those people, and to stay away from Young Middle School.
She's in business. Does she still have a child at that school?
Does she? I'm not sure.
Okay, who's representing Ms. Hargrove?
I'm sorry, I was sending an email and I thought we were going to the conflict cases. This is my case.
Okay, and so did you hear the recommendation, Ms. Wills?
I did not.
Okay, it was a signature bond through pretrial, $3,000 signature bond through pretrial. No further violent contact with Ms. Ray and Mr. Thomas. No drugs, alcohol, or weapons while out on bond. Does any of that you have a problem with?
No objection, and my client states that this upcoming school year, she won't have any children that will be enrolled at youth middle.
Okay, so is it young middle or is it youth middle?
Yeah.
Yeah, I'm sorry.
Okay, no, that's fine. So so stay away from young middle school also. Okay. Good luck to you, Ms. Hargrove.
And this is position number 18, Your Honor.
Okay, and this is Mr. Latavius Thomas. Good afternoon, Mr. Thomas. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
That's fine.
Thank you. Mr. Thomas, you've been charged in case 23 CR 004314E with simple battery and disrupting a public school. Is there a history, Ms. Jackson?
Defendant has 2 cycles. The defendant's last arrest was October the 27th, 2004 in Fulton County for simple battery and battering. There was no disposition for that arrest and nothing in addition, Your Honor. Well, I
Thank you.
apologize. I apologize to the courts. He was convicted of that. That case, Your Honor, was in 2005 for 2 counts of battery, family violence. Nothing in addition.
Okay. Yes, Ms. Bickerstaff, are these the same facts as the last case?
Yes, it's the same facts. The only thing to add is that Mr. Thomas, well, during the incident, Mr. Thomas pulled Miss Thomas away and he pushed Miss Lakeisha Ray, and he told Ms. Ray that I would fight a woman while Ms. Ray was in handcuffs. So for these reasons, the state's recommendation for the defendant is a $4,000 signature bond through pretrial services, $3,000 for the simple battery and $1,000 for the disrupting public school. No further violent contact with Miss Ray, as well as no alcohol, drugs, or weapons while out on bond, and to stay away from Young Middle School.
Any objection to any of that, Ms. McLeod?
I did not hear the recommendation, Your Honor.
Okay, is a signature bond through pretrial, $3,000 for signature bond for the simple battery, $1,000 signature bond for disrupting a public school, makes for a total of a $4,000 signature bond through pretrial. No further contact with whom, Ms. Bickerstaff?
Miss Ray, Miss Lakeisha Ray.
Okay, with Ms. Lakeisha Ray. Stay away from Young Middle School and no drugs, alcohol, weapons while out on bond.
I have no objection to that, Your Honor, but I do want to state that my client does have a child at the school. So I have no objection except to the stay away, because his daughter does attend that school. And my client has 4 minor children, has no significant history, and he denies all of that, Your Honor, including saying that he would fight a woman. He really takes exception to that because he said no such thing. He told me that he was just trying to get his wife and his daughter out of there. He did not confront anybody. He did not touch anyone, and he made no threats to anyone. I just wanted to put that on the record.
Okay.
Can I speak to the student or the children issue, Your Honor?
Okay, what's the issue?
Well, he is married to my client, is my understanding. Mr. Thomas is Miss Hargrove's wife. And so they have a child who's going into the 9th grade and one child that's going into the 5th grade. That's what Miss Hargrove told me. So no child will be going to that middle school this school year.
Okay, so Ms. McLeod, do you want to?
As long as there's no child going
just
there, I'm okay with it, Your Honor. I was under the impression that his child still
Okay.
attends the school. So I have no objection.
Can we ask him, Ms. McLeod?
Yes,
see
we
how that
can.
help. Mr.
Mr.
Thomas, do you have any reason that you need to be at Young Middle School? Do you have any children going there?
Not this year, no. She just recently graduated. So
Okay, so nobody, you don't have any other children that will be going to Young Middle School?
Not no time soon, no.
Okay,
Perfect.
so, all right, so we'll implement the stay away, okay?
Your
All
Honor.
right, good luck to you, Mr. Thomas, excuse me. Okay,
Thank you, Your Honor.
you're welcome.
Next, we have position 4, Ms. Shanine Davis, and position 3, Mr. Reginald Davis.
Good afternoon, Ms. Davis. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir?
Thank you. You've been charged in case 23 CR 004299G with simple battery family violence. Is there a history, Ms. Jackson?
The defendant has 7 cycles. The defendant's last arrest was February the 24th, 2019 in Fayette County, Georgia, for knowingly driving a motor vehicle on a suspended or canceled or revoked registration and driving while license suspended or revoked. The defendant did receive a nolo contendere sentence for a misdemeanor, 2021 out of Fayette County for driving without a valid license. Nothing in addition, Your Honor.
Ms. Falk?
Yes, Your Honor. This happened July 9th at 7075 Magnolia Lane in Fairburn. Defendant Reginald Davis stated he was arguing with his mother, defendant Shanine Davis. Defendant Reginald Davis stated defendant Shanine Davis was being aggressive towards his pregnant girlfriend, was getting in her face and yelling and screaming at her. And defendant Reginald Davis stated he put his arm up to prevent his mother from getting any closer. And at that point, defendant Shanine Davis slapped his arm down. Defendant Shanine Davis was questioned and stated that defendant Reginald Davis put his hands on her during the argument and she called 911. According to the police report, they stated that defendant Shanine Davis appeared to be the primary aggressor since there was a video that showed her yelling and screaming while walking toward defendant Reginald Davis and his pregnant girlfriend. And additionally, defendant Shanine Davis was observed on the video slapping defendant Reginald Davis's arm. At that point, he pushed her backwards. The state's recommendation is to both of these individuals, given their history. When I looked at defendant Reginald Davis and defendant Shanine Davis, I didn't see any crimes of violence. I'm sure pretrial will correct me if I'm wrong. But the state's recommendation is a $3,000 signature bond is to both. We are asking for no further violent contact between the parties and no alcohol, drugs, or weapons, and 1 day anger awareness. As we're asking for signature bonds through pretrial, I will state that we would at this time ask that one of these individuals, either Shanine Davis or Reginald Davis, stay away from the residence since this just happened yesterday. There hasn't been sufficient cooling off. That's all for the state.
I'm sorry, Your Honor, you were cutting out.
Who represents Shanine Davis?
I do.
Okay, and is this 7075 Magnolia Lane address? Does she live there?
Yes, Your Honor. The home currently is in her deceased husband's name, but that is her property.
Okay, and Ms. McLeod, you're gonna represent Reginald Davis?
Yes, Your Honor, it is my client's home. His father left it to him in a will.
Okay.
That's our ex-husband. They were divorced at the time of the father's death, and he left the property to his son in a will. My client does not mind having no further violent contact with his mom.
Okay, they are, all right, so let me start with Ms. Shanine Davis since she's here. Did you have any objection to any of the bond recommendations made by the state, Ms. Wells?
No, Your Honor.
Okay, so it'll be a $3,000 signature bond through pretrial, 1 day anger awareness, no further violent contact with her son, Reginald Davis, and no drugs, alcohol, or weapons while out on bond. That's going to be I'm going to, Ms. Davis, I'm going to allow you and your son, because of the condition of his girlfriend and not knowing really whose home it is, to have no further violent contact. But if you violate that bond condition, then you're just going to be right back where you are, okay?
I understand.
And Your Honor, we would like to add the girlfriend of Reginald Davis to that no further violent contact provision. I am obtaining her name now, so I can give that to the court. It appears that her name is Shaquisha Taylor, and I can give that to the litigation manager to put in the order if Your Honor agrees to order that.
Okay, yes, just if you will get it, if you'll just email it or however you get it there, that'll be fine. Thank you. All right, good luck to you, Ms. Davis. And so can we have Reginald?
It's going to be position number 3, Mr. Reginald Davis.
Okay. So, Mr. Reginald Davis, good afternoon. You've been charged in 23 CR 004298G with simple battery family violence. there's nothing to add, I'm going to give you the same bond conditions that I gave to your mother, $3,000 signature bond through pretrial 1-day anger awareness, no further violent contact with your mother, and no drugs, alcohol, or weapons while out on bond. I'm ordering no further violent contact, but if there's anything else happens, then you're just going to be right back before me and this bond will be revoked, okay?
Your Honor, can the courts understand that I was not the primary aggressor in the situation?
Hold on, Mr. Davis,
Mr. Davis,
you'll have a chance to litigate all this at a later time. You have a right to remain silent. Anything you say can be used against you. So Ms. McLeod, anything further, Ms. McLeod?
no, I just want to tell Mr. Davis, don't speak. I am here representing you. I will do the talking for you, okay?
All right, if nothing further, good luck to you, sir.
Thank you, Your Honor.
You're welcome.
Next, Your Honor, we have position number 6, Lachey Freeman.
Good afternoon, Ms. Freeman. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Of course, Your Honor.
Thank you. Ms. Freeman, you've been charged in case 23 CR 004305Y with simple battery family violence. Is there a history, Ms. Jackson?
The defendant does not have any prior arrests on file, Your Honor. Nothing in addition.
Thank you. Yes, Ms. Falk.
Yes, Your Honor. This incident happened at 2907 Main Street, East Point, which is the CVS. CVS security stated the couple was fighting inside. They met with Mr. Ronald Caffers and the defendant. The defendant stated she was pushed to the ground by Mr. Caffers. The defendant, however, admitted to striking Mr. Caffers first. Mr. Caffers was then questioned and stated the defendant called him a bitch and struck him on the neck with her keys and then walked toward him in an aggressive manner, at which point he pushed her to the ground. Given the circumstances, we did not proceed as to Mr. Caffers' case. They were actually charged together due to the fact that the defendant admitted that she was the primary aggressor and Mr. Caffers concurred with that assessment. We are asking for a $5,000 signature bond through pretrial services, no further contact with Mr. Caffers, no alcohol, drugs, or weapons, and 1-day anger awareness. It is my understanding that this is Ms. Freeman's first case, if that's what I heard correctly from pretrial.
All right. If Mr. Caffers is on the line and wishes to address the court, now is your opportunity to do so.
Your Honor,
Mr.
he was arrested on this case. I
Oh,
don't
okay.
believe he would have been out that quickly, but we would like to sound for him in case he was.
Okay. Doesn't appear that Mr. Caffers is, yes, Ms. Wells.
Thank you, Your Honor. We have no objection to the signature bond. My client is gainfully employed by EKG Concierge Security, where she'll be working as a receptionist. She was just recently hired. She and Mr. Capers do reside together. She states that nothing like this has happened before. She was very tearful when I spoke with her. She states that she and Mr. Capers live together. Again, and that is for her, well, in part because of her job, which is in Atlanta. She is from Austell, or her mother lives in Austell, and my client would not have a way to get back and forth as there is no public transportation between Austell and her place of employment. So she would like to be able to remain living with Mr. Capers. Again, she denies that this has happened before or that it will happen again. She is 26 years old. She has no children and a high school diploma with some college. If Your Honor is not so inclined to allow her to return back, I would ask for a one-time law enforcement escort so that she could pick up her belongings. Even though Mr. Capers was released or maybe in the process of being released, he doesn't have a phone number. So I was unable to even try to or attempt to make contact with him.
Okay. And until someone makes contact, Ms. Wells, to know what his desires are, it's going to be a $3,000 signature bond through pretrial per the judge. 1-day anger awareness, no further contact at this time with Mr. Capers. Stay away from if they live together, stay away from the residence. She can go back there on one occasion with law enforcement to retrieve any belongings that she might have there. No drugs, alcohol, weapons while out on bond. Certainly, Ms. Freeman, if someone speaks to Mr. Capers and his desires are different, then your counsel can seek to modify this bond so that you can have contact. But until someone speaks with him, the court is ordering no further contact at the present time. Okay. All right, Ms. Freeman. Good luck to you, ma'am.
Next, Your Honor, we're gonna go to position number 10, Ms. Gabriela Gutierrez.
I requested a breakout room for this case.
All right, so we can put her to the back.
Okay.
And we're gonna go to position 15, Ms. Jessica Lucas.
Good afternoon, Ms. Lucas. I'm Judge Eric Meyer. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Lucas, you've been charged in case 23 CR 004308G with simple battery family violence. Is there a history, Ms. Jackson?
The defendant does not have any prior arrests on file, Your Honor. Nothing in addition.
Okay. Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred July 8th of this year at 1385 Oak Haven Drive in Roswell. And this is where the defendant showed up at her ex-husband's residence, Mr. Christopher Lucas, and the defendant was intoxicated. And while en route, dispatch could hear the defendant being belligerent and loud. And so when officers arrived, they spoke with both the defendant and Mr. Lucas, and they both stated that they recently had a divorce from one another in the last year, and that Mr. Lucas was dating someone else, and his company was at the house at that time. And so the defendant came to the residence to confront, the company, and an argument ensued between the defendant and her ex-husband, and the defendant grabbed Mr. Lucas's chest and his shirt ripped. Our office was able to speak to Mr. Lucas today, and he confirmed the events in the warrant. He let us know that they share 2 children, and that this is the first time that something like this has took place between them. He also stated that he's not in fear of the defendant, and he would like to continue to have contact with her for their children. Your Honor, he stated that they needed to co-parent. So for these reasons, the state's recommendation is a $3,000 signature bond through pretrial services, 1-day anger awareness course, no further contact with Mr. Lucas, to stay away from 1385 Oak Haven Drive in Roswell, as well as no alcohol, drugs, or weapons while out on bond. And we will also ask for a third-party escort for the children. And Mr. Lucas is on Zoom, so I would like to sound for him.
Yes, Your Honor. How are you today?
Thank you, sir. If you would like to address the court, I'll need for you to raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. What would you like to tell the court, sir?
Yes, sir. I'd just like to correct some of the statements. There was nobody, I didn't have a female in my house at the time. My children were home, but they were in their bedroom. They did not observe any of the incident that did occur. In addition, I would request that there's a no further violent contact order rather than a no contact order. I think it's, for me, I think it's more in the best interest of the children so they can see that there is communication. This has never happened before, and I don't intend, or I don't assume this would happen from Jessica in the future. She was drinking, and I think it was a lapse of judgment at the time. In addition, I would also request if during these handoffs, if it's not a third party handoff, if it's just in a public location. Once again, there's never been an altercation over the past 9 years that we've known each other. And I think it would be in the best interest if the kids see that one parent hands off to another parent rather than having somebody as an intermediary. Those are my comments, Your Honor.
Okay, and you're not afraid of her?
No, sir.
Okay, thank you. I appreciate that, Mr. Lucas. Let's see, Ms. Kim, good afternoon. Is this your client?
Yes, Your Honor.
Okay, do you have, it's a signature bond is being suggested. Do you have any objection to a signature bond through pretrial?
No, not at all. We just want to make
No.
sure that we can no further violent contact. That's what my client also prefers. They have been a great co-parents. Kids are 8 and 5. She has a master's degree. She works part-time at military, and she also has a cybersecurity job. She's very professional, and when I spoke to her, she came across very non-violent at all. So I would like to request for no further violent contact.
Okay, a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Mr. Lucas, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Lucas. You also, Mr. Lucas.
Thank you, sir.
Your Honor, does that clarify the handoff procedures as well? Does there need to be a third party, or can this be?
No, I did not order a third-party transfer, so you all are just to have no further violent contact with one another. So how you hand off your children, you can do that in person if you choose to.
Thank you, Your Honor.
Okay, you're welcome. All right, good luck to you, ma'am. Who do we have next?
We're going to go to position number 19, Ms. Nevin Thal.
Good afternoon, Mr. Dahl. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 23 CR 004315B with simple battery family violence. Is there a history, Ms. Jackson?
The defendant has 2 cycles. The defendant's last arrest was May the 14th, 2006 in Kenwood County, Michigan, for a charge that counsel may want to waive sounding on. He was convicted, and a felony conviction took place in 2006 out of Michigan for that charge. And also he has a misdemeanor conviction in 2006 out of Michigan as well for embezzlement. And he appears to have an outstanding hold out of New Mexico for a failure to appear. The date on that warrant was January the 30th, 2018. Nothing in addition, Your Honor.
Would you direct that charge to me in a chat, please?
Yes, Your Honor.
Thank you.
It's a she, not a he.
Right. Yes, Ms. Bickerstaff, thank you.
Yes, Your Honor. So this incident occurred, This incident occurred yesterday at 340 Riverwalk Terrace in Johns Creek. And this is where the defendant grabbed Melody Jones's, her daughter's hair in an attempt to stop Miss Jones from removing property from the residence. So for these reasons, the state's recommendation is a $3,000 signature bond through pretrial services, no further contact with Miss Melody Jones, 1-day anger awareness course, as well as no alcohol, drugs, or weapons while out on bond. And if Miss Jones is on Zoom, I would like to sound for her.
Miss Jones to Miss. Do you know Miss Bickerstaff?
I'm sorry, I didn't hear you.
Who is Miss Jones to Miss Thal?
Her daughter.
Oh, okay. All right. Yes, if Ms. Jones is on the line, now is your opportunity to address the court if you choose to do so. Doesn't appear so, Ms. Bickerstaff. Ms. Kim?
Yes, Your Honor. My client, Ms. Thal, is 39 years old, and she moved to Georgia about 2 years ago because of her job. She's a speech language therapist, kind of like a medical professional. She has a master's degree, and she's not going to be qualified for a public defender's service. Your Honor, she is a full-time caregiver for her father, who's going through chemotherapy because he is going through, fourth stage of cancer, and it's very crucial for her to return home to take care of her father and her husband, who is disabled as well. And she has 4 children, 20, 19, 11, and 9 years old, Your Honor. And Melody Jones is 19 years old, daughter. who needs a lot of help in terms of image issue, Your Honor. We would like to request for signature on bond so that way she can return home to take care of her family members, actually 7 total, and she is the sole financial provider, Your Honor. Thank you.
Signature bond, pre-trial per the judge, 1-day anger awareness, no further violent contact with Melody Jones, and no drugs, alcohol, or weapons while out on bond.
Excuse
Good
me,
luck.
Judge, can you repeat that? You're going in and out.
$3,000 signature bond through pre-trial, 1-day anger awareness, no further violent contact with Ms. Jones, no drugs, alcohol, or weapons while out on bond.
Thank you.
You're welcome. Good luck to you, Ms. Stowe.
Position 8.
And let's see, this is Mr. Ganzenbach.
Yes.
Good afternoon, sir. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do.
Thank you. You've been charged in case 23 CR 004316F with affray. Is there a history, Ms. Jackson?
The defendant has 3 cycles. The defendant's last arrest was April the 16th, 1999 in Chattanooga, Tennessee for DUI. The defendant does have misdemeanor convictions. There's one in 1999 out of Catoosa County, Georgia for a traffic offense. And there was one in 1990 out of Catoosa County for a public trump. Nothing in addition, Your Honor.
Ms. Falk?
Yes, Your Honor. This incident happened July 9th, 2023 at 928 Canton Street in Roswell, Georgia. That's the location of Rockin' Taco. The officers responded to that location because Officer Brooks, who works an extra job, observed the victim, Mr. Stephen Langevin, lying on the ground unconscious and bleeding heavily from a severe laceration to the back of his head. Officers then spoke with Eric Moore, who stated he was having a few drinks at that location. After they were done, he insisted on walking Miss Terry Tosco out to her vehicle to wait for an Uber due to the fact that she was somewhat intoxicated. He stated as he was walking her out to the rear of the Rockin' Taco that she began walking toward Mr. Langevin, the victim, because he was a friend of hers. Mr. Moore stated that shortly after he saw the defendant crossing the street to meet Miss Tosco from a nearby lounge, and that both Mr. Langevin and the defendant got into an altercation, which led to the defendant punching Mr. Langevin with a closed fist. Officers were able to view the video at that location. They observed both Mr. Langevin and the defendant getting into a verbal altercation, and then observed them pushing each other apart. At that point, they also observed Mr. Langevin change position to where his back was not facing the video, and saw Mr. Langevin getting ready to swing at the defendant, at which point the defendant swung at Mr. Langevin with a closed fist, and then swung again, striking Mr. Langevin, causing him to pass out after hitting his head on the pavement. Mr. Langevin was transported to North Fulton Hospital due to the severity of his injuries. The state is requesting a $5,000 surety bond on this case. We are also requesting no further contact with Mr. Stephen Langevin. Furthermore, we're asking for stay away from the location 928 Canton Street, Rockin' Taco, as well as no alcohol, drugs, or weapons. I'm not sure if Mr. Langevin has been released from the hospital, being that this happened yesterday, but we would like to sound for him.
If Mr. Langevin is on the line, I wishes to address the court. Now is your opportunity to do so. Doesn't appear so, Ms. Falk. Ms. McLeod?
Yes, Your Honor. My client is 69 years old. As pretrial has said, any history that my client has is traffic related and also remote. I believe the most recent that was stated was in 1999. Some of the people on this Zoom weren't even born then. So we can all agree that this is remote. My client is retired. He was an attorney. He tells me that was his that was his profession before he retired. There's absolutely no violent history. He tells me that the alleged victim is Mr. Langevin, I believe his name is, was the one who started all of this. The lady in question is my client's fiance. They live together. There was an altercation, and as even the warrant states that the video shows that Mr. Langevin got into a fighting stance and was going to punch my client. It was just that my client was faster on the draw because he was merely defending himself. It's not in the least bit violent, Your Honor. He's 69 years old. I would ask the court for a signature bond so he can get out of jail and get back home. He has no objection to the stay away from the rocking taco. Nothing further, Your Honor.
$5,000
injury, Your Honor.
Say it again.
He did not cause the injury. The gentleman fell.
$5,000 signature bond through pretrial per the judge, 1 day anger awareness, no further contact with Mr. Langevin, stay away from the rock and taco, and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
Thank you, Your Honor. And Your Honor, that concludes my business before the court today. May I be excused?
Yes, have a good afternoon. Thank you, Mr.
Thank you.
Cloud.
Same to you.
Next, Your Honor, we're gonna go to position 22, Mr. Samuel White, position 22.
Good afternoon, Mr. White. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. White, you've been charged in case 23 CR 004312C with simple battery. Is there a history, Ms. Jackson?
The defendant has 15 cycles. The defendant's last arrest was January 2nd, 2022 in Fulton County for a DUI and driving while license suspended or revoked. The defendant, does that case appear to be still pending? There was no case number provided. It looks more like a reference number. Would you like that, Your Honor?
Yes, please.
22 TR 104640. And he does have misdemeanor convictions. There's one in 2019 for driving while license suspended or revoked, and one in 2011 for possession of marijuana less than an ounce and driving while license suspended or revoked. Nothing in addition, Your Honor.
Yes, Your Honor. So this incident occurred yesterday at 2087 Morehouse Drive. And this is where the defendant kicked in the door and began hitting Mr. Arthur Freeman in the face. And he put his hand around Mr. Freeman's neck. The two lived together. Mr. Freeman, officers noted that Mr. Freeman did not have any bruising on him, and Mr. Freeman did not complain of losing any breath. Our office was able to speak to Mr. Freeman today, and he let us know that he is the defendant's mother's boyfriend and that they all live at that location together. He let us know that he was in the back bedroom when the defendant and his mother were arguing. And then the defendant ran in the room and he got on top of him while he was laying down, and he put his hands around his neck, and he was trying to push his face away. While he was trying to push his face down, Mr. Freeman was trying to push his hand away as the defendant was trying to push his face down. And so Mr. Freeman also let us know that this encounter was brief. It was about 5 seconds. He stated he didn't lose any consciousness, but he also let us know that they have gotten into an altercation between each other before, and that on this particular time that the defendant was intoxicated, and this is the way that he acts when he becomes intoxicated. Mr. Freeman did let us know that he doesn't want the defendant to return to the residence, and he does not want any contact with him. So for these reasons, the state's recommendation is a $4,000 surety bond, $3,000 for the simple battery, and $1,000 for the criminal trespass charge. 1 day anger awareness, no further contact with Mr. Arthur Freeman, and to stay away from 2087 Morehouse Drive, as well as no alcohol, drugs, or weapons while out on bond. And I will also ask for a one-time police escort so the defendant can grab his belongings. And Mr. Freeman's on Zoom, so I would like to sound for him.
I only have a simple on my calendar. Is there also a criminal trespass?
Oh, no, I'm sorry. Those are my notes from earlier. No, it's just the simple battery. I'm sorry about that.
Good afternoon, Mr. Freeman. If you'd like to address the court, I'll need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down, Mr. Freeman. What would you like to tell the court?
His mother and I discussed this, and she said that she preferred for him not to come back to the house. And her sister, which is his aunt, and his uncle, she called them, and they said that he shouldn't come back to the house either because he doesn't work. He's been getting high on drugs for a long time. He comes in the house raising hell all the time with his mother, calling her bees and all kind of stuff. So she's tired of it. That's what they was arguing for that night. And then when I got up to try to, he was outside the door. So I just shut the door and told her not, to leave him alone. But they kept on. He got mad because I closed the door on him. But I went back and laid down, and he just came in there with all that crap. But everybody don't, they talk, they got together, they say he shouldn't be at the house. So if he get a signature bond, that's okay. But my suggestion is he don't come back there. I don't want him around. His mother, she's on Zoom too. I guess she want to say something. And the whole family said he shouldn't be allowed back at that house.
Okay, does he have any belongings at the house that
Yes.
he'll need to get? Okay, so I'm going to allow him to come with law enforcement to retrieve.
Like I said, he could sign a signature bond.
Okay, all right. Thank you, Mr. Freeman. And is this his mom on the Samsung?
Yes,
here?
yes, sir.
And what's her name, Mr. Freeman?
Angela Allison.
Yes, Ms. Allison, if you would like to address the court, I'm happy to hear from you. You'll have to unmute yourself and I have to swear you in if you like to address the court. If you like for Mr. Freeman's to have spoken for you, then I'm happy. But if you have something that you want to tell me, then I'm happy to listen. Okay, I'm not sure if she has.
Yes, sir.
Okay. Do you swear from you're about to give before this court be the truth, the whole truth, about the truth?
Yes. Yes, sir.
Okay. You're not in a good spot for me, ma'am, because I can't really hear you and you keep going in and out. Can you hear me?
Yes, sir.
Okay, and do you have something more that you want to tell me other than what Mr. Freeman has told me?
Yes, sir. I would just like to add, if there's anything that we can do, any kind of class we can take for alcohol and drugs, he needs help with that. He needs some kind of program or some kind of rehab that he can go to for the alcohol, drug from me. So that's the only time you act up like that. And I'm afraid for him to be in the house around us lately.
Okay. All right. Thank you, ma'am. Ms. Kim?
Yes, Your Honor. My client, Mr. White, is 36 years old, and he has 4 children, 18, 8, 4, and 1 month old. He has been working as a forklift operator for about a year, and he is actually employed and working. That's what I was told. So he's not qualified for public defender's services. He graduated from high school 2005. Your Honor, he has to be responsible for 4 minor children, and financially, he has to help them out. So we would like to request for a signature on bond so he can return and take care of, go back to work and take care of his children, Your Honor. Last offense was something to do with a DUI. I would like to, my client says that he does not have any issues with the drinking or drugs. So we would like to request for a signature on bond. If Your Honor is not inclined to give him a signature on bond, we ask for $1,000 good bond as a maximum. We have no objection to stay away and no further contact. Thank you.
It's going to be a $3,000 signature bond through pretrial per the judge. 1-day anger awareness. No further contact with Mr. Freeman. Stay away from the Morehouse Drive address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond. So, Mr. White, I'm gonna, you have a right to remain silent, Mr. White. I'm gonna give you a signature bond, but if you violate any of the conditions of this bond, you're gonna be right back where you are. You understand me?
Yes, sir.
All right, good.
That's through jail or pretrial?
That's through pretrial. Okay, good luck to you, Mr. White. You also, Mr. Freeman.
Next, we have position number 12, Mr. Josiah Johnson.
Good afternoon, Mr. Johnson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. You've been charged in case 23 CR 004303C with simple assault, 2 counts of obstruction of a law enforcement officer, and second count of simple assault. Is there a history, Ms. Jackson?
The defendant has 10 cycles. The defendant's last arrest was November the 4th, 2015 in Fulton County for 3 counts of aggravated assault, possession of a firearm or a knife during commission of a felony, and possession or transport of a firearm by a convicted felon or felony first offender, and criminal street gang activity. The defendant does appear to be on probation for those charges. That case number is 16 SC 140762. That disposition date was October the 24th, 2016. 5 years of confinement and 10 years of probation. Nothing in addition, Your Honor.
Thank you, Ms. Bickerstaff.
Yes, Your Honor. So this incident occurred yesterday at 800 Cherokee Avenue. This is near the zoo entrance. And this is where officers arrived and they spoke with Mr. Bryant Sexton and Kyle Dixon, who informed them that the defendant made several threats to them to leave the area because he was selling ice cream in that area first. And so as they continued to speak with the defendant told them that he would force them to leave. And then he left and went to his U-Haul truck. And so when the defendant came back, he was holding his waistband tightly, and it appeared that he had an object that resembled a gun in it. And so Mr. Dixon asked the defendant whether he was going to use the gun on them. And to keep in mind, Mr. Dixon is only 15 years old, and the defendant stated that kids carry guns all the time and that he would use the gun on them. And Mr. Dixon recorded this encounter. And so when officers arrived, they were able to locate the defendant where on two separate occasions, and 2 different officers had to tell the defendant to stop fleeing from them, which he ignored. But officers were able to place the defendant under arrest. And after reviewing the recording of the incident, officers heard the defendant state that he was gonna go get his stick, which is his gun. And so our office was able to speak to Mr. Dixon, and he let us know that he and Mr. Sexton are co-workers.
I know what he did.
And then what he said, I'm gonna tell. And that's what he did too.
Can we Sam sound, please? Thank you. I'm sorry, Ms. Bickerstaff. Go ahead.
Yes, that Mr. Sexton and Mr. Dixon, they were co-workers at Glacier's Italian Ice. Excuse me. And they just had gotten there and they were unloading the ice cream from the van. And he let us know that the defendant came to where they were and wanted them to go away. And he started to threaten them with the gun and having the gun outlined in his pants, Your Honor. Mr. Dixon also let us know that he and his coworker frequent at that location where they sell ice cream. So for all of these reasons, the state's recommendation is a $22,000 surety bond, $10,000 on each of the assault charges, and $1,000 on each of the obstruction charges. No further contact, excuse me, no further contact with Mr. Sexton or Dixon, as well as to stay away from that area, and no alcohol, drugs, or weapons while out on bond, and no firearms at all, Your Honor. And I believe Mr. Moore or Mr. Dixon is on the Zoom call. I would like to sound for them.
Mr. Dixon or Mr. Sexton is on with us this afternoon and would like to address the court. Now is your opportunity to do so. You'll have to unmute yourself, activate your camera, and I'll have to swear you in.
Mr. Dixon.
Yes, Mr. Dixon, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down, sir. What would you like to tell the court?
We would like to have the no contact be completely with our business. We have more than one location and one park that we frequently go to. That includes this Grant Park that's near the zoo. So I would not like it to be specifically just me and my coworker, but the business as a whole, because we have multiple young men who are of the ages of 14 through 17 that go to our parks with us each day and not just the weekends.
Okay, and what's the name of your business?
Glacier's Italian Ice.
I'm wearing sweatpants.
All right, anything further, Mr. Dixon?
I do not have anything else to add.
Okay, Mr. Moore, if you would like to address the court, I'll need for you to raise your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, you can put your hand down. Yes, sir.
I agree with the state's recommendation. The only thing is just exactly like Mr. Dixon said, to expand it to the entire business and nonprofit. I just wanted to make it for the record that we're also a 501c3. So we hire young men in the community as an alternative to the Atlanta Water Boys through our nonprofit diversion services. So we want to make sure that we keep our youth safe, educated, and employed, and that they're safe. They can do their transactions and work for us safely. So I just wanted to state for the record that we're also a nonprofit organization working with the youth in Fulton County.
Okay, thank you, Mr. Moore. And let's see, Mr. Johnson, you have a right to remain silent. Anything you say can be used against you. If you would like to speak to Ms. Wills before, I'm happy to give you that opportunity, but let her speak for you so that you don't get yourself into any more trouble, okay? Ms. Wills?
Thank you. My client is 33 years old, as it was stated. His last arrest was 2015, and he has not been arrested since then. Although there was a lot of testimony provided or proffer provided in regards to a gun, there was no mention that a gun was actually located or found on my client's person. My client tells me that he is employed by Ruby's Frozen Treats. He's been employed there for the past 2 years. He was at the location first when the Glacier Italian Ice truck also arrived to the location. He did ask the youth if they could relocate or move their truck so they weren't in such close proximity, given that they do sell the same or similar products. And he states that the youth were very aggressive toward him. And so he does deny the allegations as the state alleges. My client also was made fun of by law enforcement after his arrest to add insult to injury. For those reasons, I would ask for a signature bond. If not, I would ask, currently my client's bond is set at $10,000. I would ask that that bond be reduced to a bond of no greater than $5,000. I would ask, I do understand the concerns of the business owners. I would ask that my client just stay 200 yards away from where any Glacier Italian ice truck may be located. If they are there first, that he would just have to find another location to sell his ice cream. Mr. Johnson, you don't need to say anything else. You'll have the opportunity to fight these charges at a later date. It's just your bond hearing.
I would just like to express my sincere apologies towards those men and also the young men and that whole company, because I don't want the backlash to body back on Ruby's frozen treats. And that was all the cause of everything, because we had a verbal misunderstanding. And I will admit to the verbal misunderstanding.
Hold on, Mr. Johnson.
I never threatened anybody. I never.
Mr. Johnson, stop. Can you mute the courtroom, please?
Well, I don't need him to leave, but Mr. Johnson, don't, it's not, what you're saying is not doing you any good, okay? All right. So it's going to be for the simple assaults, $1,500 good bond per charge. For the obstruction, a $500 good bond per charge. So it makes it for a total of a $4,000 surety bond. No further contact with Mr. Dixon or Mr. Sexton. Stay 200 yards away from any Glacier Italian ice facilities. No drugs, alcohol, or weapons while out on bond.
Honor, that was a $4,000 surety bond?
Yes.
Thank you.
I'm sorry,
Okay.
Your Honor, I apologize. Can I get that breakdown again? I apologize.
Of course. No, that's not, it's $1,500 for each of the simple assaults and $500 for each of the obstructions.
Thank you.
Okay. All right, Samsung, we can still hear you. So can you mute yourself? Can we get that Samsung muted, please? Thank you.
Next, we got position number 13, Tyrone Johnson.
Okay, good afternoon, Mr. Johnson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
I'm sorry, Mr. Johnson, I can't hear you, but my only question to you is, do you agree to have your case heard by video?
I said, yes, sir.
Oh, okay, all right, thank you, Mr. Johnson. You've been charged in case 23 CR 004306J with obstruction of a law enforcement officer and simple assault family violence. Is there a history, Ms. Jackson?
The defendant has 32 cycles. The defendant's last arrest was January the 9th, 2023, and that was in Fulton County for criminal trespassing and obstruction of an officer. Your Honor, this is going to be a bond surrender. The defendant was out on a signature bond through pretrial services for criminal trespassing in public drunk. That case number is 23 CR 000155 and a letter F. The defendant does have prior felony convictions. They're out of Florida, one in 2015 for possession of cocaine with the intent to distribute, one in 2011 for possession of controlled substance, and one in 2009 for possession of cocaine. And he does have misdemeanor convictions. They're out of Florida, one in 2019 for possession of marijuana less than an ounce, and a hit and run, one in 2012 for possession of marijuana less than an ounce, and one in 2009 for petty theft. An additional one in 2009 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Ms. Bickerstaff?
Yes, so this incident occurred yesterday at 314 Skipper Place. And this is where officers, upon their arrival, they heard a male identified as the defendant yelling and banging on the door. And when they approached the door, they observed the defendant standing in a fighting stance. And so officers asked the defendant what was going on. And the defendant stated that his girlfriend, Miss Shanika Melton, locked him out of the house. And so officers noted that the defendant appeared to be on some type of drug due to his speech. It was slurred, he was sweating and rambling. And so officers asked the defendant to calm down and to stop banging on the door, but the defendant ignored their command. And so when Miss Melton opened the door, the defendant attempted to get in Miss Melton's face and he flinched at her while his fists were balled. The officers then arrested the defendant, and then as the officers were placing him under arrest, the defendant tensed up and he stated, "I'm going to book." Our office was able to speak with Miss Melton, and she let us know that they have one child together and they are no longer in a relationship, nor do they live together. She let us know that she's moved on from the relationship with the defendant. In fact, that she's in a relationship with someone else where they are expecting a child together. She also let us know that the defendant doesn't live there, but instead, he keeps coming to her residence. And so on this particular day, the defendant was outside her residence yelling and banging on the door for about 3 hours. She let us know that their shared child currently lives in Florida, so there's no need for a third-party transfer for the child. She let us know that she does not want any contact with the defendant and she wishes that he stays away from her residence. So given all of that, the state's recommendation is a $3,000 surety bond, $2,000 for the simple assault and $1,000 for the willful obstruction, 1-day anger awareness course, no further contact with Ms. Melton, and to stay away from her address at 314 Skipper Place, as well as no alcohol, drugs, or weapons while out on bond. And if Ms. Melton is on Zoom, I'd like to sound for her.
Do you know anything about the previous bond and its conditions?
No, Your Honor, but I can let me look it up.
Okay, if you'll do that for me while Ms. Wills is giving her presentation.
Thank you. And I believe Miss Shanika Melton is on the call. I see Anika's World. I'm not sure if she heard.
Okay. If Ms. Melton is on the call or wishes to address the court, now is your opportunity to do so. So Ms. Shanika Melton, either she doesn't wish to address the court, Ms. Wells, or she's not with us at the present time.
Understood. My client is 36 years old. He has resided in the state of Georgia for the past 3 years. He is currently suspended from work, so he will qualify to be represented by the Public Defender's Office. And so he does have very limited income. He does have a high school diploma. He has one 9-year-old child. My client states that he and Ms. Melton Ms. Melton was upset with him after he didn't come straight home after they had gone out. He was knocking on the door. He says that he was unaware when law enforcement came up behind him, that they did not announce themselves, so that when the officer did come upon him, he caught my client by surprise. And this was very early or in the late hours, depending on how you look at it in the morning. My client states that he is still in a relationship with Ms. Melton, and that he did comply with law enforcement's commands and did abide by what they requested of him. He states that the officer was extremely aggressive with him, that he slammed him to the ground, punched him several times. My client states that he suffered a broken nose, rib, and tailbone as a result of the law enforcement's action, and actually had to be taken to Grady after his arrest. If Ms. Melton, obviously, if her desire is that there is no further contact, my client does understand that and will abide by that. And he does live at an address, a different address other than what is listed in the warrant. I would request a signature on bond. And if Your Honor is not so inclined, I would ask that his bond not be greater than $1,000. My client also, he definitely does deny that he ever acted in a threatening manner towards Ms. Melton.
Thank you, Ms. Wilkes. Anything, Ms. Bickerstaff?
I'm still looking, Your Honor.
Okay, and that's fine. It's Ms. Wells, you want to address your client?
Yes, Mr. Johnston, you don't need to say anything else. This is just your bond hearing. I promise you, anything you have to say to the court is not going to be beneficial at this juncture. Unless you have a question, I advise you to just wait until the judge gives his order. Do not speak on the facts of the case.
He's adamant, Ms. Wells, so Mr. Johnson, you have a right to remain silent. Anything you say can be used against you. If it has to do with the facts of the case, I will take your counsel's advice on that. If it has to do with something else that won't affect your bond, then or you want to clarify something, but know that anything you say can be used against you, sir.
Yes, sir. I totally understand, sir. All that I want to say is that I have seen clothes in her apartment just in case you find it in your heart to let me out.
Okay, so you're saying that you need to go pick up your clothes. So if you have things that are there, I'm going to allow you one-time escort with police officers to retrieve any belongings.
Yes, and I just wanted for Ms. Bickerstaff to look up all the information from Grady, the punishment that I have suffered.
Mr. Johnson, I already spoke to all your injuries. I already said that.
Okay, well, I'm sorry. I'm done, Ms. Williams. My nose already and my throat already hurt. So I barely can talk anyway. So I'm sorry.
Well, I suggest you stop talking then, since it hurts.
Your
Hey,
Honor,
yes, Ms. Falk.
did you inquire about the conditions of the previous bond on?
I did.
Trespass? Okay, let me just confirm with pretrial. We have 23 CR 0000155F. Is that what pretrial has?
Yes.
Okay, that's a stay away from the Hamilton home, MARTA, Your Honor, $3,000 signature bond, random screens, no alcohol, drugs, or weapons. It was signed by Judge Law, January 10th, 2023.
Okay, so he's already getting random screens for drugs and alcohol. All right, anything further? If not, it's going to be a $1,000 surety bond for the obstruction, a $2,000 surety bond for the simple assault, makes for a total of a $3,000 surety bond. No further contact with Ms. Melton. Stay away from the Skipper Place address. He can go back to that address on one occasion with law enforcement to retrieve any belongings, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Johnson.
You're done. You're done. You're done. It's over.
So I'm gonna
It's over.
I ain't gonna send you on.
No. Come on. Come on.
Look at you. 7. Next, Your Honor's position 7, Virgil Fusion. Fuson.
Come on. 2 weeks. 2 weeks.
Please move.
Come on. Come with me, man. This way, Johnson. This way, Johnson. You really don't want to do it right now. Come on. You really don't want to trust me, man. I never see you.
All right, good afternoon, Mr. Fuson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You've been charged in case 23 CR 004310E with simple battery family violence. Is there a history, Ms. Jackson?
The defendant does not have any prior arrests on file, Your Honor.
Okay. Ms. Falk?
Yes, Your Honor. This incident happened July 9th, 2023 at 5005 Eves Place in Roswell, Georgia. The defendant slapped Mr. Quezada in the face with an open hand. He and the defendant have resided together for 3 years, and according to the warrant information, are in fact married. The defendant admitted to slapping Mr. Quezada in the face. Mr. Quezada is here. We did not have an opportunity to speak with him, but I would like to hear from him before we give our bond recommendation.
Yes, good afternoon, Mr. Quezada, if you would like to address the court, now is your opportunity to do so. I will need for you to unmute yourself and I'll have to swear you in. And you'll have
Hello?
to.
Hello, can you hear me?
Can you activate your camera for me? I cannot see you.
Okay. I don't know, it's the first time using this and
Okay, you're fine, sir. Can you raise your right hand for me?
Yes.
Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. What would you like to tell the court?
So just only I want to say like drop the charges like with my husband Virgil Fuson, because that night I called the police for possible like violence or something like that, but he never is like a person like violence. And we lived like together for 3 years, and I think like 2 or 3 years together. And that night we was drinking alcohol. Only like the problem was that like the alcohol like start like we was having a pool party and we was having a discussion, and that is the only that the problem was the alcohol, no other things. Like I'm good with him and just like apologize to everybody because like call the police like 911 like when it's not like a really emergency. And it's embarrassed to me to be here, and it's a lesson to me in my life to be in this like problem, like because of to be like present in the court. And I don't know, like I don't feel like in danger with him. Like he always a good person with me. Only that happened that night.
Okay, and did you call the police because you were slapped, Mr. Quezada?
Yes, I called the police that, but that is more. That don't was like like for example like hurt or fighting or something like that. Like that night was more like the drama with alcohol.
Okay, has this happened before?
No, normally we have like discussion like normally like with anybody, but nothing dangerous or something like that. We never have like really problems.
Are you afraid of him? Did you hear my question, Mr. Quezada?
No.
Are you afraid of him was the question.
How I'm afraid?
Are you afraid of him?
No, I'm not afraid for sure, like 100%. I'm not afraid about him. Like I feel like safe with him for sure. Only the problem, and repeat again, that night was the alcohol, and that's it.
Okay, Ms. Falk?
Yes, Your Honor, based on that and largely because the defendant is 55 years old and has never been arrested. The state is agreeable to a $3,000 signature bond through pretrial services. We are requesting no alcohol, drugs, or weapons. Since it's Mr. Quezada's statement, this may have been alcohol related. We are, however, requesting no further contact with Mr. Quezada. This just happened yesterday, and we would like a slight cooling off period and a stay away from 5005 East Place in Roswell. We're also requesting 1-day anger awareness. That's all for the state.
Ms. Kim?
Yes, Your Honor. My client, Mr. Fuson, is 55 years old, and he has been an original owner of window tinting for car small business ever since 1987. He has been here all time. He was born and raised here in Georgia. He has a bachelor's degree. Your Honor, he's not going anywhere. He has been very good citizen. This is his first ever being in trouble. Mr. Mao is not afraid of him, so we would like to request first no further violent contact. 5005 East Place is actually his house that he bought in his name, and he's the one who's paying for the mortgage. Thank you, Your Honor.
It's going to be a $3,000 signature bond through pretrial per the judge. 1-day anger awareness, no further violence. Say it again. I don't know who's speaking.
I apologize, Your Honor.
Okay, $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Mr. Quezada, and no drugs, alcohol, or weapons while out on bond. Good luck to you both.
Thank you.
Position 14, Mr. Patrick Keys.
Good afternoon, Mr. Keys. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Keys, you've been charged in case 23 CR 004307A with battery, family violence, and criminal trespass. Is there a history? Ms. Jackson?
The defendant has 2 cycles. The defendant's last arrest was April the 25th, 2016 in Rockdale County, Georgia, for a charge associated with the CWAC. The defendant does appear to be on probation in Rockdale County for those charges. That disposition date was May the 10th, 2017. The term is for 7 years. He also appears to have 2 outstanding holds, one out of McDonough, Georgia, for simple assault. The date on that warrant was May the 4th, 2023, and that was one out of Conyers, Georgia, for a probation violation. The date on that warrant is June the 1st, 2023. Nothing in addition, Your Honor.
Thank you. Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred June 22nd of this year at 989 Washington Street. And this is where Miss Erin Alcomfar, I'm sorry if I mispronounced that name, but it's spelled Augcomfar. This is where Miss Erin told officers that her husband, the defendant, questioned her about whether or not she was cheating on him. And during this conversation, the defendant became upset and he slapped Miss Erin in the face. She let officers know that the defendant also threw her around the apartment and shoved her to the ground. Officers did note in the warrant that she sustained a scratch on her nose from the attack. She let officers know that she tried to leave, but the defendant stopped her, and he threatened to harm himself if she did. And during the dispute, the defendant damaged Miss Erin's phone. And so the next day, the defendant returned to the residence and he tried to replace the broken phone. Our office did have the opportunity to speak to Miss Erin. She let us know that they are married, but they do not live together. And she also confirmed the events listed in the warrant. She let us know that the incident location is the defendant's residence and she lives somewhere else, and I'll put it in the chat. She let us know that is the residence that she stays at is her mother's residence, and that the defendant is not allowed to come to that residence. She also let us know that this is not the first time that the defendant has been violent with her, but this is the first time that the police have been called, Your Honor. For these reasons, the state's recommendation is a $6,000 surety bond, $5,000 for the battery charge, and then $1,000 for the criminal trespass, 1-day anger awareness course, no further contact with Miss Erin, to stay away from her address, which I will put in the chat, and as well as no alcohol, drugs, or weapons while out on bond. And I would just like to bring to your attention that the defendant has an open aggravated assault, aggravated battery, and a battery family violence case right now. And that case number is 23 CP 946. 219-946. The defendant didn't receive a bond on that case, but it is a different victim than Miss Erin in that case. But I thought that is good for you to know. And if Miss Erin is on Zoom, I would like to sound for her.
Seeing Erin there, if this is you, Ms. Akapar, and if you would like to address the court, now is your opportunity to do so. You would have to unmute yourself, activate your camera, and I would have to swear you in if you would like to address the court. Yes, ma'am. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell the court, ma'am?
I know that this issue that of the violence that's been going on is just secluded to a drug matter, and it's not on his own. He's a really good person, husband, and I would prefer to have just a no violence and not the no contact.
Okay, why is that?
Because I'm still married to him, and we are trying to actually work out the relationship.
Okay, and did you find it necessary to call the police back in June?
At the time I did.
And why did you call the police?
I felt very frightened.
Okay, all right, thank you, ma'am. Let's see, Ms. Kim?
Yes, Your Honor. Mr. Keys is 39 years old. He was born in New Jersey. However, he moved to Georgia when he was 5 years old. So he's been here for about 34 years. And he has a job as a subcontractor for property management. Actually, he's the one who's improving the 8 units building that he is residing right now, 989 Washington Street. That is his residency, where he also has a job. He works and repair that area, that building. That's his job. He graduated from high school, and he prefers to have no further violent contact because Miss Erin they have been married, and there has not been any problem. It has been already more than 20 days, 3 weeks. We would like to request for signature on bond and no further violent contact. Your Honor, there is anyway no bond for the felony charges, so he cannot get out of the jail even though he gets signature on bond for this one. Thank you, Your Honor.
Right. For the battery, it's going to be a $2,000 surety bond. For the criminal trespass, $1,000 surety bond, which makes for a total of a $3,000 surety bond. At this point in time, and given his history, I don't I think that it's a good idea for there to be contact, so no further contact, and stay away from Ms. Aaron's address, no drugs, alcohol, or weapons while out on bond. Good luck to you all. Who do we have next?
Position number 6, Mr. Patterson.
Yes, good afternoon, Mr. Patterson. I'm Judge Eric Moore. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. You've been charged in case 23 CR 004309H with battery family violence. Is there a history?
Yes, he has 17 cycles. The defendant's last arrest was March the 11th, 2021 in Fulton County for a probation violation. He does appear to have an open case pending in Fulton County for possession of controlled substance, Schedule 2, with the intent to distribute, and possession of controlled substance, 2 counts, and possession of marijuana less than an ounce. That case number is 22 SC 183411. In addition to that, the defendant appeared to be on probation in Fulton County for aggravated battery and aggravated assault. That case number is 17 SC 151871. That disposition date was March the 20th, 2018, and the term is for 8 years. He does have prior felony convictions. One in 2017 for obstruction of an officer, and he received first offender treatment in 2017 for theft by receiving stolen property and furnishing a pistol or a revolver to a person under the age of 18 years of age. That case was sealed September the 22nd, 2022, and he has misdemeanor convictions. One in 2018 for theft by taking and obstruction of an officer. It's an additional one in 2018 out of DeKalb County for theft by shoplifting, and one in 2015 for driving without a valid license. An additional one in 2015 for giving false information to an officer. He does appear to have a history of failure to appear. It's one in 2018 and two in 2016. Nothing in addition, Your Honor.
Speaker staff.
Yes, Your Honor. So this incident occurred July 8th of this year at 3856 Fair Drive. And this is where officers received a disturbance call, and they were notified that that the defendant and Miss Danielle Baldwin left the residence and they were walking up the street on foot. And so when officers made contact with Miss Baldwin, she informed them that her and the defendant had been arguing outside of the residence over where the defendant had been all day in Miss Baldwin's vehicle. And so Miss Baldwin told officers that the defendant pulled her in the house and he began punching her in the face. And officers noted Ms. Baldwin to have 3 knots on her head, and she had bruising under her eye due to the attack. And the defendant told officers that when he came home, Ms. Baldwin was arguing with him about him being out all night. And he did admit to the argument becoming physical between the two. And he acknowledged that he was the primary aggressor in this altercation. The two, Ms. Baldwin and the defendant, have been living together for the past 6 months. Our victim witness advocate was able to speak to Ms. Baldwin today, and she let us know that her and the defendant are in a relationship, and that the defendant stays with her from time to time. She did confirm the events listed in the warrant, and she also let us know that this was the first time that the defendant had been violent towards her. She also let us know that she's not fearful of him, and that she does not want to press charges against him, Your Honor. Nevertheless, this incident occurred 2 days ago, so the state just wants to make sure there's been an adequate cooling off period between them. So the state's recommendation, given all that and the defendant's history, is a $3,000 surety bond, 1-day anger awareness course, no further contact with Ms. Danielle Baldwin, to stay away from 3856 Fair Drive, as well as no alcohol, drugs, or weapons while out on bond. And if Ms. Baldwin is on Zoom, I would like to sound for her.
Okay, you're right. If this is Ms. Baldwin, you're on mute.
Can you hear me now?
Yes, ma'am. Can you raise your right hand for me?
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, what would you like to tell the court?
I just wanted to tell the court that me and Larion, we've never had this type of situation before. We did get into an argument. I said a lot of hurtful things. He said a lot of hurtful things. I do not feel that he is a threat to me. With the no contact order, our children, well, his son and my daughter, well, his son is living at my house. His son is like my son. We've been, having our kids together for like 3 years. So I don't feel fearful for my life. This is something that has never occurred before. I've never called the police before in this manner. And he doesn't have a history of being violent towards me. I do not believe that he's ever going to be violent towards me again. And I believe that our argument just got heated and escalated.
And you found it necessary to call the police, is that correct?
Yes, sir, at that time I did. But when I think about it, we could have probably talked it out and got less worse. But I was angry as well. And I'm human and I do have a temper.
Okay, and where were your children at the time?
Our children were asleep, so they never saw anything. They didn't wake up. They weren't aware of anything because the way our house is set up, they were in the basement asleep.
All right, thank you, ma'am. Ms. Kim?
Yes, Your Honor. My client, Mr. Patterson, is 26 years old, and they have two kids together, 8 and 9 years old. He is employed. He does work as a handyman out of the mud landscaper. He's completed up to 11th grade, and then he got GED. However, his employment, even though he has odd jobs, his income is not high enough. So he's qualified for public defender services, and our team will be continuously representing him. Your Honor, Mr. Patterson and Ms. Baldwin are engaged. They're about to marry, and they would like to have a no further violent contact. And also, we would like to request for a maximum $1,000 good bond. Thank you.
All right, it's gonna be a $3,000 surety bond, no further violent contact with Ms. Baldwin, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Patterson.
Honor, I apologize. What was the amount again?
$3,000 surety.
Thank you.
You're welcome.
Position number 21.
Good afternoon, Mr. Whitaker. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Unmute for me, courtroom 2.
Yes, sir.
Thank you. You have been charged in case 23 CR 004313Y with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Ms. Jackson?
Yes, the defendant has 12 cycles. The defendant's last arrest was July the 12th, 2022 with the City of Atlanta Police Department for possession of controlled substance, Schedule 1 or Schedule 2, and obstruction of an officer. The defendant does appear to be first offender probation for 2 different cases that ran concurrently together. One is for aggravated assault, and that case number is 22 SC 183168. That disposition date was February the 3rd, 2023. 1 year of confinement, 5 years of probation, and he appears to be on probation for robbery and aggravated assault. That case number is 22 SC 185260. That disposition date is February the 3rd, 2023. 1 year of confinement and 5 years of probation. There was no sealed date available. He does have prior misdemeanor convictions. It's one in 2019 for possession of marijuana less than an ounce. One in 2017 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you. Ms. Guggenstein?
Yes, Your Honor. So this incident occurred Saturday, July 8th of this year at 2800 MLK Junior Drive. And this is where Miss Melissa Balak advised officers that her ex-boyfriend, the defendant whom she once formerly lived with, came to her house unannounced and questioned her about the company she was having. And so when Ms. Balak told the defendant that he needed to leave, he became upset and he swung at her, attempting to hit her. And then he grabbed her face, and Ms. Balak hit him to get him off of her. And then the defendant grabbed her and pushed her on the couch, and then he kicked her in the leg. And Ms. Balak's 13-year-old son, TB, was present and witnessed the attack, and he tried to break up the altercation between the two. Officers did note in the warrant that Ms. Balak sustained redness and bruising from the defendant. And so I would like to let you know, along with what pretrial was saying, the defendant has hindering a person's 911 call, battery, family violence, and cruelty to children under 20 MGAC 02191. And in that case, he's on probation with the conditions to have no further violent contact with Miss Melissa Balak and to complete an FVIB course. And so here we are again with violent contact with her. So the state's recommendation is a $10,000 surety bond, $9,000 for the battery, family violence, and $1,000 for the cruelty to children. 1 day anger awareness course, no further contact with Miss Balak, to stay away from 2800 MLK Junior Drive, as well as no alcohol, drugs, or weapons while out on bond. And I see that Miss Balak is on Zoom, so I'd like to sound for her.
Ms. Blaylock, if you'd like to address the court, now is your opportunity to do so. Your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, what would you like to tell the court?
I don't need no stay away contact order. We finna have a baby. I'm currently 3 months. And I just feel like we both need to seek anger management because I hit the toy first. He's tried to push me down to keep me from hitting him, but it's just the things that he say bothers me. So I'm not gonna say he's aggressive because he's not. Let's just get that out the way. I can say I'm to blame for half of the things that have happened, but the thing is he will not call the police on me, and I suffer from mental illness as well, currently off medication. So it's not just him. Let's get that clear. But I do not need no violent stay away contact order. Period.
Well, let me just tell you, Ms. Blaylock, I'm going to order it, and I'm telling you why. This isn't the first time that y'all have been here with this, and y'all are grown folk. Y'all got children, okay? Regardless of whether you say you did it or he says he did it or whatever, y'all are raising some children around this, okay? So no, I'm not going to have you around him or him around you, especially now that you're here back again, and you've been here before. So no. I'm going to order no further contact whatsoever. And if there's any contact, then he's going to be right back where he is right now. Okay? You all need to think about the children that you're raising. Ms. Kim.
Yes.
You're on mute, Ms. Kim.
I apologize, Your Honor. Mr. Whitaker is 24 years old. He is working as a mover. He completed up to 10th grade, and then after that, he was enrolled for GED, but he could not complete yet. Your Honor, he has no issue with a drinking or a drug, no MHE issues. Since even though he prefers to have a no further violent contact, we totally understand that Your Honor is going to order no further contact. He can stay with his grandmother at another location. We would like to request for $1,000 maximum good bond. Thank you.
Okay, for the battery, it's going to be a $4,000 surety. For the cruelty, $1,000 surety, makes for a $5,000 surety. No further contact with Ms. Blaylock. Stay away from the MLK Junior Drive address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond. As I said, you all need to consider these children that you're raising. No contact means absolutely no contact. If you violate that, you will be right back here before me again, Mr. Whitaker, and you won't, and this bond will be revoked. Good luck to you both.
I have a question.
Yes, ma'am.
So when it comes to our baby's appointments and for deliveries, how would that work if there's no contact?
I'm hoping that you have a very successful pregnancy, Ms. Blaylock, but you're the one who called the police in this regard that he was laying hands on you. You're pregnant. Given that, he could have been had a different charge, I would imagine, if the solicitor had known that you were pregnant at the time that this allegedly happened. So that would be a simple battery or battery against a woman who was pregnant. So you need
Man,
to
I
think.
just found out I was pregnant. So all this stuff y'all got going on, I understand. All right.
Okay, all right. Good luck to you both.
Mm-hmm.
Position number 10. Your
All right. We need a breakout room for position 10. Is he the last one in the courtroom this afternoon?
She's not, but you also got position number 1. That's last.
Ms. Wills has requested a breakout for position 1.
Okay,
To
and
address both.
okay, and let me see. So those are the last 2 cases. Yes. Okay. So if we can go into a breakout, who all needs to be in the breakout room? Okay, so
I think all the public defenders and all the ASGs.
Right. Okay, so if you can put us all in a breakout room, please.
Mm-mm.
What you say?
Said Melissa? Melissa?
Who is that? Who is that? Mm-mm. You don't want me because nobody don't know my name.
Go around.
One of our shares?
Yeah. Yes, ma'am. Yeah, ma'am. So that's it. Right. They are, and that's the 11th. Okay. It's a lot of stuff in my schedule. And a lot of them. The wrong days.
These are all closed out. Which one? That's all. But there's only. Oh, the bathroom. What you doing first, then? But you know, 14. I'm not coming in because I'm not agreeing to nothing. I told you that. I'm not. I'm sorry. You have to find me a replacement, baby. All right?
Okay, so may I see Mr. Arnold? Good afternoon, Mr. Arnold. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're doing by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Yes, Your Honor.
Okay. Mr. Arnold, you've been charged in case 23 CR 004296C with simple battery. I've had an opportunity to discuss your case with your lawyer and the solicitors. At this time, it's going to be for the simple battery of $4,000 surety, for the disorderly $1,000 surety, making for a total of a $5,000 surety bond. You're to have no further contact with Ms. Riddick and Ms. Ramirez, no drugs, alcohol, or weapons while out on bond, and we're going to have a social worker visit you. I'm going to see you back if you don't get out on July 25th, and they, at that point in time, I'll have your lawyer report to me regarding getting you some help for some of the issues that you might have. Okay.
All right. Thank you, Your Honor.
All right. I'll see you back on the 25th, sir. Okay.
Yeah, Your Honor, I apologize. What position was that?
That was position number 1.
That was
Mr.
5,000.
Yes, and there was a disorderly that was added, so I don't know if you have that. So it's 4,000 for the simple battery, $1,000 for the disorderly.
Thank you.
Okay. And let's see, this is Ms. Gutierrez. And yes, Ms. Gutierrez, we've also had an opportunity to discuss your case while we were in the breakout room with your lawyer. It's going to be the bond, a $3,000 surety bond. Let's see, no further violent contact with your mother, Ms. Carter. There's going to be a mental health evaluation and no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Ms. Gutierrez. Okay. Thank you all. We'll see you next time, courtroom 2. And Ms. Grace, do you coming in and out? I don't know if you were trying to address the court or not. Okay. Ms. Bridgewater, I think that completes the calendar. So whenever you're ready, we can go over it.
Okay, I'm ready. Position number 1 is reset to the SAP calendar. Oh, let me start by this. Reset date for the SAP calendar is July 25th. Position number 1 did in fact have another charge added. This case is going on the SAP calendar with a total $5,000 good bond. Position 2 is going to the SAP calendar with a $2,000 good bond. Position 3 is reset further notice with a $3,000 SOB through pretrial per judge. Position 4 is reset further notice with a $3,000 SOB through pretrial per judge. Position 5 is reset further notice with a $5,000 SOB through pretrial per judge. Position 6, reset further notice, $3,000 SOB through pretrial per judge. Position 7, reset further notice with a $3,000 SOB through pretrial per judge. Position 8, reset further notice with a $5,000 SOB through pretrial per judge. Position 9, reset further notice with a total $2,000 SOB through the jail. Position 10 is reset to the comp calendar for July the 20th with a $3,000 good bond. Position 11 is reset further notice with a $3,000 SOB through pretrial per judge. Position 12 is going to the SAP calendar with a total $4,000 good bond. Position 13, SAP calendar, with a total $3,000 good bond. Position 14, SAP calendar, with a total $3,000 good bond. Position 15, reset further notice, with a $3,000 SOB through pretrial per judge. 16 is going to the SAP calendar with a $3,000 good bond. Position 17 is going to the SAP calendar with a $1,000 good bond. Position 18, reset further notice with a total $4,000 SOB through pretrial per judge. 19, reset further notice with a $3,000 SOB through pretrial per judge. Position 20, reset further notice with a $5,000 SOB through pretrial per judge. 21 is going to the SAP calendar with a total $5,000 good bond. And 22 is being reset further notice with a $3,000 SOB through pretrial per judge. Are there any questions, comments, corrections? No? Well, I guess that's it. Judge, you're breaking up. We can't hear you.
Enjoy the rest of your afternoon. Thank you.
Okay, simply put, okay. Take care, everybody. Oh, who's doing the, I guess the mental health eval? I guess they'll get it to me.
Okay, and it should have been Ms. Wills.
Okay, thank you, Judge.
All right.
All right, bye-bye.